So, Mr. Vice Chancellor, judges, professors, friends from SIAC, students, and everyone else who got up this early on a Saturday morning to come and learn more about commercial arbitration. And thank you, Prof. Harry, for the introduction. I have to say that Prof. Harry sent me an email that dates from 2016 in which the late Martin Hunter introduced me to Prof. Harry, and it was in conjunction with a VIS competition in Vienna, I think. And I mentioned that because for those of you who are international arbitration, commercial arbitration students, you will have read Redfern and Hunter. And they were real people. They are real people. Martin Hunter, who died a few years ago, is a good friend, and Alan Redfern is a good friend. I worked with them at Freshfields, where I was head of the International Arbitration Group, along with Jan Paulsen. And I mentioned them because they were really committed to developing younger practitioners and students and welcoming them, as I am here, you into the field of international arbitration. Now, I know that last year our fellow SIAC court member, Dr. Claudia Anneker, as Prof. Harry mentioned, delivered the inaugural NLSIU-SIAC annual lecture on sunset clauses in bilateral investment treaties, which is a very erudite and interesting topic, especially for me, because that's my field, investor-state arbitration. And by the way, Prof. Harry, I'm not counsel anymore. I'm only an arbitrator. So I enjoyed Prof. Anneker's lecture, having spent 40 years in this field since I started doing it at the Iran-U.S. Claims Tribunal, where we dealt with expropriations and international contract breach. I thought, though, for today, that I would take a different approach, a more practical, practice-oriented approach, and specifically, I want to address what I see after these 40 years as somewhat basic misconceptions about real life in international arbitration. And I will also take the opportunity to thread in some of the new 2025 SIAC rules, which are showing, which we enacted upon demand of users mostly, but they show the evolution of international commercial arbitration over the years. And for those of you who are here not in the field, per se, of international commercial arbitration, I want to stress that it's a procedural specialty. It is not a substantive specialty. It's a procedural specialty which underlies a dispute that comes from some substantive area of the law and some sector of commerce, and therefore rules are critically important to the practice. And anyone who wants to practice in the area has to like civil procedure and evidence. So I will focus on some rules. Now, I'm not using slides today on purpose. I'll pretend to be a professor again and say, I think that in this age of multitasking and constant phones and everybody paying attention to 3 things at once, we forget how to listen sometimes. So I'm not putting up slides. So a few points of this talk, I'll ask you to listen carefully as I quote some of the relevant laws that I'm talking about. So, of the 5 things you think, or at least I think you know about international arbitration that you don't know, thing 1 is this: international commercial arbitration is preferred over litigation because it is more time and cost efficient than litigation in national courts. The answer is no. That is wrong. Commercial parties prefer international commercial arbitration over litigation because they do not trust or feel comfortable in the courts of the counterparty. Now, that could be fear of judicial corruption. That could be fear of delay, which is something, of course, I hear about a lot, or you hear about a lot in India. That could be fear, as happens in the United States, where I'm from, fear of juries, fear of triple damages, fear of perceived unlimited discovery in litigation. And it could just be fear of the unknown. A common lawyer, general counsel not wanting to be involved in a civil law jurisdiction. And these fears can be reasonable, by the way, or they can be unreasonable. A second reason is that court judgments are not enforceable internationally as easily as an international arbitration award under the New York Convention. And I'll come back to the New York Convention. It's always surprising to US lawyers when I tell them that there's not a single bilateral United States treaty for enforcement of a court judgment, which is why the big companies, when they have cross-border disputes, prefer international arbitration. Now, it is true, no doubt about it, that domestic arbitration is used because it should be more cost-effective and less expensive and faster than national court litigation. But think about it this way. Ask yourself this. If you're representing a company let's say it's an Indian company, in a cross-border dispute with tens or hundreds of millions of dollars at issue, and guess what? You could lose. You can always lose. And the ultimate award, arbitration award, is more or less enforceable quite quickly under the New York Convention with no avenue of appeal on the merits, including, as happened to me in my private practice a few times, a patently wrong decision on the law or the facts. Does your client want a very fast and very inexpensive proceeding in international arbitration, paying very little to inexperienced lawyers in order to do this quickly? No. International arbitration in the major cases is not supposed to be really fast and really inexpensive. You're talking big ticket items with a lot at risk, much more so than in litigation. So it also surprises my colleagues when I say, well, at Freshfields, advising clients, I often said, go to court if you possibly can, because you'll have appellate rights and you'll have police power for enforcement. But if you don't want to be in the courts in Afghanistan, then perhaps it's best for us to put an arbitration clause. So that is one thing I think your teachers won't necessarily tell you, but in practice that's important. Thing two, and I'll spend the longest time on this, international commercial arbitration awards are readily enforceable under the New York Convention or the ICCA Convention, almost like magic, almost like getting breakfast in the morning. No, that's also wrong. So I want to talk about the New York Convention of 1958. It's true that that is most likely the most successful treaty ever, with 172 contracting states now. It's also true that under Article 5 of the Convention, an international commercial, or in fact treaty award can be set aside or denied recognition and enforcement in national courts on very limited bases, including violations, really severe violations of natural justice, violations of public policy, or the fact that the case was not supposed to be arbitrated. But recognition of an award in a national court is not the same as enforcement, and it's certainly not the same as execution against getting money if you've won a monetary award. And this is important to remember. So in a normal, well, there have to be accessible assets if you're going to really win with a capital W, an international commercial arbitration case. For students going out into practice in let's just say a normal sale, purchase, contract, agreement dispute, however normal it is, you have to think ahead. In the case of parties that are state-owned entities or states, there are the extra issues of sovereign immunity that come into play with enforcement and execution. So basic lesson is don't assume that the New York Convention will solve all your problems if you win an arbitration. I used to say to my students at NUS, actually I did this very dramatic thing I can't do up here. If the blackboard was behind me, I would start at this side of the room and say, oh, okay, client comes to you and there's a dispute. It looks like an interesting dispute, a solid dispute to go to international arbitration. And you start right away writing your request for arbitration. And then I would walk all the way across the room and I would say, and over here, we have you're trying to collect the, let's just say, $10 million that you've won after 3 years of arbitration. Where you have to start thinking about whether you can collect that $10 million is over here when you're drafting your request for arbitration. And it's almost malpractice per se now for international arbitration lawyers not to do the due diligence at the beginning to confirm that there are attachable assets if you win your case. And there's various ways to do this, but now it's really mandatory to know the source of funds that you might be able to collect in the possibly relevant jurisdictions where your counterparty would have assets. Now that I'm fortunate that there's a very recent case involving an Indian government entity, just a week ago, case that gives you a story about what real life can be like in pursuing an arbitration and enforcement of an arbitration. So this is the case of, some of you will know about it, it's Devas et al. Versus the Republic of India. The citation is 2025 EWHC 946. It's at the High Court of Justice, Business and Property Courts of England and Wales, the Commercial Court, King's Bench Division. Now, before I talk about the case, this is when I want you to listen. I want you to keep in mind a couple of provisions. The first is the New York Convention, Article 3. Students will know this by heart probably. And I'm going to read it. Each contracting state shall recognize arbitral awards as binding and enforceable in accordance with the rules of procedure of the territory where the award is relied upon, which would be the state where you're trying to get enforcement. That's the New York Convention. Sounds great. It's going to be binding and enforceable in accordance with the rules of procedure where you want to get your money. Now, the UK Sovereign Immunity Act of 1978, it's a bit longer quote, says this. Section 2(1) says a state is not immune in respect of proceedings in respect of which it has submitted to the jurisdiction of the courts of the United Kingdom. 2.2, a state may submit after the dispute giving rise to the proceedings has arisen or by a prior written agreement. Section 17.22, references to a prior written agreement refers to a treaty, a convention, or other international agreement. So, New York Convention, you get to go and enforce in accordance with rules of procedure in territory and under the Sovereign Immunity Act in the UK, as with many states, the state has to submit somehow to waiving its sovereign immunity. So this story is a bit long one, but this is how real cases can play out, especially with investor state. And I have to thank Shanine Parikh of Cyril Amershon Mangaldas for telling me about this case last week. I think the decision is just April 17th, so brand new. So the background is this. In 2005, Devas Multimedia Private Limited, which is an Indian telecoms company, went into contract with Antrix Corporation Limited, which is an Indian state-owned entity, commercial arm of the Indian Space Research Organization, I'm told, to provide satellite services in India. In 2011, that's 6 years later, Antrix invoked force majeure and terminated the contract, citing, as is usual, Indian national security policy. So Devas started an ICC arbitration. And in 2015, an ICC tribunal awarded Devas about US $560 million for an unlawful termination of that contract. The Delhi High Court set the ICC award aside under Section 34 of the India Arbitration and Conciliation Act because the award, because the contract had suffered from patent illegalities and fraud as a violation of public policy. In 2023, the Supreme Court here rejected the appeal of setting aside of an ICC award of over $550 million. Now, as happens almost all the time now, foreign shareholders of Devas, based in Mauritius and Germany, started 2 bilateral investment treaty cases against the government of India. Now, it's important, these were not ICCA cases, these were UNCITRAL cases. The hearings, I guess, were in The Hague. So the New York Convention is going to apply to an award, unlike an ICCA case. So, meanwhile, back home, Devas was liquidated based on allegations that the original contract with Antrix was tainted by fraud. And in 2022, the Indian Supreme Court upheld that liquidation decision, rejecting the argument that Antrix was stopped from pleading fraud because it had failed to raise fraud in the ICC arbitration. Now, outside of India, the shareholders of Devas, the foreign shareholders, assigned their rights to US affiliates, and in 2022, same year, 3 Mauritian shareholders brought, I'm sorry, I left out something important. We've already got 2 bit cases going, and then a third bit case starts up against India, alleging that India had pushed, I quote, an audacious scheme, the government of India, through Antrix, an audacious scheme to avoid paying $550 million ICC award. So the foreign investors are trying to enforce and collect the bit awards that they then won against the government of India, against the New York Convention. What was India's defense? Sovereign immunity. In Australia, India lost. First, no sovereign immunity, but then the Federal Court of Australia said India does have sovereign immunity and doesn't have to pay that ICC award under the international law theories of the bilateral investment cases. So then, as often happens, the Mauritian shareholders and the US parents, who can be very aggressive, tried going to the United Kingdom, to the London Commercial Court. In 2021, they won an enforcement order, enforcement of the arbitration award ex parte. And India then said, as I would have, we'd like a stay of payment of that $550 million on grounds of sovereign immunity while we challenge the BIT awards in Dutch courts. Why Dutch courts? Because the PCA was administering the investment treaty cases and the hearings would have been on Dutch soil in The Hague. So again, just about 10 days ago, 17th of April, Sir William Blair issued his ruling in the UK case. It's a long opinion. It's 40 pages long, very erudite, a lot of information on the international law of sovereign immunity, and I can't say I've studied it thoroughly, but the outcome is very clear. First, apologetically, I would say, Sir William wrote that he observed that the shareholders had, quote, made a formidable case as to the extraordinary delays with enforcement that have occurred elsewhere in the world and will occur in England if the issues related to state immunity are required to be determined, end quote. Remember, this contract dates 20 years ago, 2005. But Sir William held that India's ratification, and this is where it matters, India's ratification of the New York Convention, a treaty, did not constitute a waiver of sovereign immunity under the relevant English sovereign immunity law, because there's no indication in the New York Convention that the drafters intended to preclude immunity. And intended to preclude immunity-based arguments based on rules of procedure. They intended, if anything, to preserve procedural rules of sovereign immunity. And under the UK statute, as in most, sovereign immunity is a procedural protection against payment. So that's a long story about how a serious case can play out when you're looking at rights, or defenses, I should say, under the New York Convention. Now, I want to take you on a comparative detour to what would have happened in an ICCID case, or not. ICCID Article 54.1 says this: each contracting state to the ICCID Convention, which is almost as many as the New York Convention, shall recognize and award as binding and enforce the pecuniary obligations, only a monetary award, within its territories as if it were a final judgment of a court in that state. So if you get an ICCID award and you take it to India or New York, you say, enforce this award just as if the highest court in the US or India had issued this award. Section 54.3 goes on, though, to say that execution of the award shall be governed by the laws concerning the execution of judgments in force in the state in whose territories execution is sought. So you take your award, but you're going to be subject to what the local courts do with execution with their own judgments in that country. But this is important. Article 55 of the ICCID Convention also says, nothing in Article 54 shall be construed as derogating from the law in force in any contracting state relating to immunity of that state or any foreign state from execution. So even with an ICCID award, which is an extraterritorial, extra-national proceeding, if you get the award, you can get it recognized easily, you can get it technically enforced easily in a foreign court, but if the laws there or the practice of the procedure there says you can't execute against a state-owned entity or a state, you don't get anything. And these chases are now going on for years. So the lesson is the New York Convention is not a panacea. Even the ICCID Convention is not a panacea for the ultimate success, even if you do the best job you can and win your case in investor state or commercial arbitration. And sad to say, over my many years in this area, it's now become the norm for regular companies, but all state-owned entities and states to resist enforcement after many years and many $1 million of attorney's fees. Singapore is a notable exception, by the way, in this area. So that's just some realpolitik for what you think you know about the reliability of the New York Convention. Now, the others are easier. The others are easier. Thing 3, international arbitration is flexible, more flexible than litigation, allowing the parties to control the proceeding. For that, I think I have to say yes and no. It's true in international arbitration that the parties generally select the rules, they select the institution, if any, or ad hoc. They select the seat, they select the governing laws of the contract, of the arbitration itself, and most importantly, they select the members of the tribunal. And in doing that, parties can take account of their specific disputes, their specific contracts, their specific sectors, and their desired relief. And in particular, look for arbitrators who will understand energy disputes or blockchain disputes compared to the average judge who has to be a generalist. So no doubt it's more flexible than court litigation, but my observation here is this flexibility, the power of parties has gone too far. Tribunals, many tribunals, not always, are either out of laziness or out of what we call due process paranoia, allowing the parties to get away with way too many delays, way too many applications, way too long pleadings, way too much of everything, which is not helpful overall, in my opinion. I gave the Freshfields lecture now quite some time ago, I think 2016, where I talked about the abuse of due process by the parties in international arbitration. And I feel pretty passionately about this because law is a learned profession. It's a principled profession. It's based on laws and rules and ethics and proper behavior. And the role of due process, or what we call due process, called natural justice, is extremely important, and it is a protection. Due process is a protection of the rights of, in this case, a party in a dispute. It is not a sword that should be used to intimidate a tribunal, to make strategic gains against the other side. And in one case I did, there were so many objections based on due process from the other side that the tribunal said, fine, we understand. At the end of this hearing, just give us a written document of how many times we violated due process in this hearing. And it ended up being 3 pages, single-spaced. And it included things like when one of our witnesses we got to the end of the time for cross-examination of our witness, and you didn't give us time, extra time, that's a violation of due process. When you took a break in the middle of a cross-examination, it was a violation of due process because we lost our train of evidentiary thought. When you wouldn't give us 2 extra days of hearing after the hearing days have been set for 2 years, that's a violation of due process. That is not a violation of due process. That is not what due process is about. Due process is about each side having its case heard. And in that lecture, I found very interesting, in preparing for it, I found very interesting negotiating history and the evolution of the UNCITRAL model rules and law, where the phrase says each party shall have an equal right to present its case. It's very clear, an equal right to present its case does not mean unlimited right to present the case. So tribunals should be, in my opinion, and it's how I try to run my cases, much firmer in how they manage the procedure and not bow to due process paranoia. There are no court cases. There are no court cases that are going to set aside an award because a witness cross-examination was limited in time, or because the tribunal refused to extend the length of a hearing when the length had already been agreed. So the courts are here. The tribunals, in my opinion, need more stiffening of the spine, I call it, in order to maintain charge of a proceeding that the parties may have set up and structured, but it has to be run with discipline. So for the practitioners in the audience, and I'm not charging you with anything, but at least in my cases, I'm seeing increasingly long written submissions in international arbitration. It's not unusual to have 400 and 500-page memorials. And then what's more troubling is you have a memorial, a counter-memorial. The reply is supposed to be limited. The claimant's reply is supposed to be limited to points in the statement of defense, but then the reply is like 800 pages. And then the rejoinder, which is supposed to be limited to the new points in the reply, is 1,000 pages. And the footnotes, I can't even tell you how many millions of footnotes there are sometimes. So I'm exaggerating, but not by much. So we are actually at SIAC, where we're always under, not us, but the profession is under criticism for efficiency, lack of efficiency. We're exploring putting out a practice note that will encourage tribunals to set page limits, not just on the closing submissions, which is common, but on all of the written submissions, on the applications, on the arguments in support of document production, requests. Of course, we can't say they must be 50 pages. It can't be like our Supreme Court that says 30 pages, the U.S. Supreme Court. But we can encourage arbitrators to tell the counsel to, back off a bit, because these pleadings are repetitive. They're very repetitive. It's not as if they deserve much. We're also, by the way, though, reading my pencil note from the plane last night, we're also trying to put more discipline on tribunals to deliver their awards more quickly, more expediently. So in our new Rule 53.2, it's required for a tribunal to submit the draft award to SIAC not later than 90 days after the last written or oral submission in the case. The old rule said 45 days after the closing of proceeding. Now, I will plead guilty up here, and I know this is being recorded, so I should better be careful. I will plead guilty in cases to holding off on closing the proceedings until the award is completely written or just about written, so I know I'm within my 45 days. But now, wisely, our users and our court members have said far more helpful to tell a tribunal you only have 90 days after the last written or oral submission comes in. And Rule 53.1 even says that the tribunal has to give a notice 30 days after the last written or oral submission as to when the award will be in. I guess it's not, the tribunal can't say, well, it will be in next year. It's supposed to be within the next 60 days at some point. Now, I predict that there will be instances where sneaky tribunals will ask for written submissions to try to get extra time, but we'll see what happens. I think the criticism against tribunals for taking too long to issue awards in many cases, not all by any means, but in many cases is fair. But again, I ask you a rhetorical question. If you are counsel for a party in international arbitration on a case you've worked on for 3 or 4 years and put in several memorials, many exhibits, witness statements, expert reports, it's a bit unreasonable to want your tribunal within 30 or 60 days to produce a fully reasoned award, even if the tribunal's been keeping up with your submissions as they come in. The fact that you took so long doesn't mean that you get the tribunal to take very little time to give you a fair and reasoned award. So thing 4, this is more for the practitioners than the students. Thing 4. Institutional international arbitration, especially at the major institutions like the ICC, SIAC, LCIA, HKIAC, Alphabet, is unduly expensive. No, I promise you that is wrong. I know I'm treading on dangerous ground here in India, where arbitration is mostly ad hoc, but I'm talking about the overall international arbitration practice. In a pure ad hoc arbitration, again, I'll leave India out because you're used to ad hoc arbitration, the parties and the council will need to agree on the procedural rules. They're going to have to agree on an appointing authority, unless everybody has to run to the national courts if you need to challenge an arbitrator or get over a bump. And you need to find a tribunal willing, and this is often an impediment, willing to hold the monetary advances personally in escrow, or find someone else to hold the funds in escrow. And in law firms, they don't like to hold party funds in escrow. There's liability there. This can be a very expensive and time-consuming process, and it often fails. I recently, I don't know, self-punishment, I guess, I took on a position chairing a tribunal, three-person tribunal in a purely ad hoc case. The arbitration clause just says any disputes will go to arbitration. There's nothing more than that. I thought it would be interesting because my other ad hoc arbitrations have all failed at the procedural stage because of complexity. One of the first things that happened is one of the parties, it was a Brazilian party against an American party, challenged the arbitrator who'd been appointed by the other side, and then wrote a letter to me saying, you know, we look forward to your deciding the challenge. And I said, well, it's going to be a long wait because there are no rules. I have no authority to look at this challenge. We have no authority to do anything. If you want to challenge this arbitrator, you're going to have to go to court. And we are sitting in New York, so at least they know they would have to go to New York court. So I said, you know, come back next year. We'll be waiting happily to see what happens. They withdrew that challenge, by the way. And we found an organization, a maritime organization, that would hold the funds in escrow. It's a quasi-maritime case, only to find out later that that organization takes 50% for itself of the fees that are paid to the arbitrators. Well, neither here nor there. I don't do this for money. Anyway, a better option is to decide on agree on a set of ad hoc rules. The UNCITRAL rules are extraordinarily useful in any commercial or commercially focused arbitration. They answer almost every question, including what happens with a challenge proceeding, so long as you have an appointing authority. And if you don't, then the Secretary General at the PCA will provide an appointing authority. The next best option is, if you depict, say, the UNCITRAL rules, have the Permanent Court of Arbitration, or SIAC, depending commercial or treaty, administer the case, or at least hold the funds for you, and things will go more smoothly. And then the next best option, and in my experience over 40 years, the best option is to have an institution that's efficient administer the arbitration. And so the institutions, as you know, have two models. One, the ICC and SIAC both have set arbitrator fees and administrative fees on a pro rata basis, depending on the amount alleged to be in dispute. Other institutions have the arbitrators and the charge on an hourly rate, and they have admin fees. Hong Kong, you can do either, which can be useful. So there is a popular misconception, I have to tell you, that arbitration using pro rata administrative and tribunal fees based on the amount in dispute are way too expensive. ICC too expensive. SIC is too expensive. That is just not true overall. It is true in those institutions that a very high value case can be relatively easy to resolve, and the arbitrators even if they make the lowest of the pro rata amounts, they make quite a bit of money, and the admin fees are profitable. But equally, and seemingly more often in my cases, a low value dispute can be exceedingly complicated, and it's a very, very good value for the parties to have used ICC or SIAC, and the arbitrators end up getting paid at like $50 an hour in order to do a complicated case. So you just can't say it's always true that the pro rata institutions are too expensive. And by the way, in assessing costs, we have our registrar sitting in the front row, Vivek Neelakantan. He takes into account the complexity of the case when deciding what the arbitrator fees will be, and so does the ICC. Now, how about institutions with hourly rates, the LCIA, AAA, others? Generally, they're managed well, but they can get out of control, and I personally have seen abuses of hourly rates by arbitrators. But the real problem is not abuses by arbitrators. It's that you have, as a company going into arbitration, you have no idea what it's going to cost. At least in ICC and SIC, you know how the most expensive it could possibly be, and therefore you can plan for it. And it's very tough for institutions to challenge the hourly rates put in by arbitrators. So amidst all of the criticism of international arbitration for being too expensive and inefficient, SIC has, in the January 2025 rules, come up with an entirely new procedure. And I want to briefly describe it to you. It's what we call the streamlined procedure. It's in Rule 13 of our new rules, which I will promote here, and Schedule 2. Here's how it works. By default, for a claim under 1 million Singapore dollars, that's about, I'm not sure, maybe 800,000 US dollars, the claim automatically goes to the streamlined procedure. So 1 million Sing dollars streamlined. 3 months from start to issuance of the award. Sole arbitrator of necessity. The default, although it can be adjusted, is there will be no applications, no witnesses, no experts, no document production, and no hearing. And this is what I want the practitioners to listen to, the tribunal and the SIC fees will be capped at 50%, 1/2 of the normal SIC fees in our tables of pro rata fees. Now, I want to add that a couple things. There's a safety valve. If a claimant files a case, and it's already happened actually this year, that's under 1 million Singapore dollars, the respondent can apply to SIC, to the president actually, to say, please don't use streamlined. It's too complicated. It's impossible for this case to get through in 3 months. There's an issue that's going to require experts or fact witnesses or a hearing. And in the one case that's come in like that, I have decided as president, that's right, it shouldn't go to streamlined. So there's a safety valve there. And these are all default things. So you can imagine a very focused case. I had to do a case once where a lot of money was on the table, but all the arbitrators had to do, well, it was a hard thing to do, but we had to interpret a formula that 2 tech companies had agreed to use in the future if something happened. And when something happened, they disagreed on how the formula worked. That really would have been perfect for streamlined because there was no need for more than a remote hearing. We could have done it. And that I mentioned to say parties who have disputes valued at more than $1 million Singapore can ask for streamlined procedure, but they'll have to consent. They'll have to consent to do it and come to us. So this is the first time there's been anything like this in international arbitration, and I can tell you from our few days in Mumbai that there's a lot of excitement, even amongst the big companies, for when they have small disputes, rather than go ad hoc, that they could find an efficient institution to do it. I'm on my last thing, thing 5. This is more for the students than the practitioners. Thing 5 that you think you know. The life of an international counsel or arbitrator is glamorous. Okay, sometimes it's glamorous. Less glamorous is at 2 in the morning, this international arbitrator ironing her suit in the hotel room because it looked like, I don't know, it had been run over by a car. Well, preferring to sleep. But more seriously, it is true, I have, over my years as counsel and arbitrator, enjoyed international travel to many places. Exhibit A, India, my first trip to Bangalore at least. In fact, I've lived in the usual places. I've lived and worked in Paris, London, The Hague, Hong Kong, and Singapore. One of the best places I went to in terms of glamour was Nepal on business. I took the case, maybe I shouldn't say this while I'm being recorded. I took the case in part because the hearing would be in Kathmandu, and my husband had always wanted to do some trekking. And it was really good investment of time because while I was chairing the arbitration and he was doing some trekking, he came back and he said, "I've given up my dream of climbing Everest." So I don't have to listen to that anymore. But it was a fascinating hearing. Travel, well, I also, because of casework that I did on 3 related investment treaty arbitration cases, went to Turkey 36 times. So some of that was glamorous, but not all of that was glamorous. And I certainly have enjoyed staying in some very nice hotels, including the Oberoi, and flying business class. And I will give you one more family anecdote here. When my son, who's now a grown-up computer engineer, was, I don't know, 11 or 12, he told me he wanted to be a lawyer. And he had 2 reasons. He likes to argue, that's true, and he would like to fly business class. So, well, this is a true story. One morning, a Sunday morning, I was in the kitchen and I was doing, for me, an unusual construction case. And I was on the phone with my Italian clients talking about their dispute with a client in Latin America, and the conversation went on about half an hour like this. Okay, claim 1001 about the rust on the roof of the fertilizer factory, claim 5,000 million on the broken sidewalk outside the factory. And when I hung up the phone, I kid you not, this little face looked up at me and he said, "I changed my mind." And he is not an arbitration lawyer or any lawyer at all. But overall, the travel can also be very difficult and very tiring. The hearing days are long. Remote hearings during COVID were particularly difficult. 2 weeks sitting from 10 at night until 4 in the morning. I love remote access to case management conferences, to oral arguments just by the lawyers. It saves a lot of money, and it's good for the environment not to fly so many people around just to do something between the lawyers. But the hearings with evidence and witnesses are, in my experience, better in person. And I wrote a note to myself, I seem to spend a lot of time washing clothes in hotel sinks. So it's not that glamorous. And the demand on arbitrators, for those in the audience, practitioners and students alike, who really want to get an arbitrator appointment. And that's increasingly, I hear that increasingly, more than I ever did. Everybody wants a first arbitrator appointment. The demand on your attention is very high as an arbitrator. To be a good arbitrator, you cannot let your attention lapse for a minute, for a second, because you'll miss an objection, you'll miss an overstatement. Whereas the counsel are sharing advocacy duties. They go in and out of the room. The witnesses are on, but then they're off. The tribunal secretary is in the back of the room, particularly if a camera is on you. And now I know in some big cases, the law firms put, I'm not kidding, assign an associate just to look at the face of each arbitrator through the whole hearing, looking for raised eyebrows or, well, some people fall asleep, but that's not me. But it's very demanding and very tiring if you're going to make sure due process really is observed through the hearing, especially if you're the chair. So why have I done this my whole career? It's not for glamour. It's for the challenge and variety in the practice. I think it's not saying too much that international arbitration is the last refuge of the generalist in law. If you're going to do disputes, every case is a new sector, new parties, new counsel, new tribunal colleagues, meeting people at the institutions, new stories, getting to know each other. Most important for me as a lawyer, though, well, actually most important is the people and the experiences But the legal challenges are extremely interesting. You're dealing with foreign law, you're dealing with public international law, private international law, comparative law, with all these facts and people and witnesses. It's like a big jigsaw puzzle to go from the request for arbitration to an arbitration award. And I won't go back to the execution hurdle that we all have. So in conclusion, the one thing I want you to know about international arbitration, and know correctly, that it is a privilege to practice in this field, especially since it's a small and a niche field, and I'm grateful for having had that privilege. I'm grateful to be president of the Singapore International Arbitration Court, which is an astounding organization, to have my colleagues who are here. And, well, I won't go through all your names. They know who you are. And to have the privilege of visiting Bangalore for the first time and seeing your university people and meeting so many of you. So with that, I thank you for your attention on an early Saturday morning.